Started. Welcome, everyone, to our first webinar of the Cannabis Research Center in 2026. Today, we'll be sharing work focused on research around tribal sovereignty in California's cannabis permitting and land use programs. I'm Ted Grantham. I'm a professor of cooperative extension in the Department of Environmental Science, Policy, and Management at UC Berkeley. I'm the faculty director and one of the co-founders of the Berkeley Cannabis Research Center, which was formed in 2017. I'm joining you all from the East Bay, and I'd like to acknowledge that UC Berkeley is located on Ohlone lands, and to offer my respect and gratitude to the original stewards of this place. For those of you who aren't familiar with the CRC, we study the social and environmental dimensions of cannabis agriculture. We employ interdisciplinary and collaborative approaches to conduct research and outreach that informs public discourse, policies, and programs around cannabis. So thank you so much for tuning in. Before we jump into the webinar today, I just want to do a couple housekeeping notes. Please use the Q&A bubble here to post questions that may come up as you hear from our presenters and panelists. We also have a closed caption option for those of you who may want that functionality. And then, feel free to react and share any responses to what you're hearing today. After a brief introduction, we're going to dive into our project presentations, and then we'll have some time for open Q&A and discussion. So hope to have a nice balance of presentation and conversation. So for those of you who aren't familiar with the CRC, I mentioned that already. I guess I'm excited to share that the CRC is still very active and exploring new frontiers. We recently were awarded several new grants from the Department of Cannabis Control, including projects focused on horticulture, science, hemp regulations, and environmental benefits of licensure. You're likely to hear more about those projects in the future, and I also want to highlight these upcoming events. In March, we're going to have another conversation around trends in California's unlicensed cannabis cultivation since legalization, so we have some new research around that. And then in April, we're going to be organizing and participating in this Cannabis Environmental Stewardship Symposium at Cal Poly Humboldt. So please mark those on your calendar. But today, we have the opportunity to share work that was conducted over the last couple of years and focuses on this intersection of cannabis permitting and land use with issues related to tribal sovereignty in California. So it's my great privilege to introduce today's speakers, Seth LaRosa, Jeremy Sorgan, Anna Starkley, and Earl Crosby. First, we're going to hear from Seth and Jeremy. Seth LaRosa is a PhD candidate in environmental science, policy, and management here at Berkeley, who's been working with Dr. Van Butzik in a land use change lab and as a researcher with the Berkeley Cannabis Research Center. His research examines the intersection of indigenous sovereignty, environmental policy, and cannabis regulation in California, with a focus on how cannabis cultivation and regulatory frameworks shape environmental outcomes for communities and the environment. Seth uses mixed methods, including remote sensing, ethnography, and policy analysis to investigate land use change dynamics in the state. Jeremy is an assistant research professor at Mills College at Northeastern University and Provost Impact Fellow. His research interests include tribal sovereignty and environmental policy and land use decision-making policy solutions to facilitate access and stewardship, environmental ethics, and environmental justice. His current research focuses on tribal cultural resource management in California, intergenerational storytelling, trespass cannabis remediation, and the tribal cannabis market. We also have Earl Crosby and Anna Starkley with us. Earl Crosby worked for the Crook Tribe Department of Natural Resources and Environmental Policy for over 20 years, and he's interacted extensively with local, state, and federal government officials in a staff-to-staff capacity, and he now works as a consultant. So we're very happy to have you here today, Earl, to share your thoughts. Anna Starkley is the Tribal Historic Preservation Department Manager at the United Auburn Indian Community of the Auburn Rancheria. She has a master's degree and background in archaeology And she works closely with UAIC's Tribal Historic Preservation Officer and is responsible for all government to government tribal consultations with federal, state, and local agencies, ensuring compliance with AB 52 and Sections 106 of the National Historic Preservation Act, including archaeological and biological review and GIS database management, geospatial analysis, and mapping. So we're very fortunate to have you here today as well. And I look forward to hearing what you all have to say. I'm going to end my screen sharing and allow, I believe, Seth to take over.
Just getting it going here. I hope that opened up. Can you see my screen, everyone?
We
Yes.
can.
Excellent.
Great. Thank you, Seth. Thank you for the introduction, Ted, and Peng for all the work that went into organizing this webinar. We're excited to share kind of final results after quite a few years. Seth, next slide, please. So this project examining tribal sovereignty and cannabis permitting on native ancestral lands actually started back in 2021. And originally we had 2 years with funding from the Department of Cannabis Control. And then we got an extension to 2025, which was a really good thing. And just last summer and last fall, we were kind of wrapping up some of our final deliverables, including a consultation policy template that we hope tribes will find useful for establishing consultation policies or strengthening their policies where they already have them. The PIs for this project are Jennifer Sauerwein, Van Butzik, and Peter Nelson, all based in ESPM at UC Berkeley. And Seth and I worked closely on kind of shepherding the project along. But the real brains of the outfit were our 7-member advisory crew. And these folks are geographically dispersed across the state and have collectively decades of experience working in cultural resource management. And so really the project was not possible without them. And they brought a lot of the on-the-ground experience and crucial connections to people that we spoke with to understand what was going on in cannabis permitting and around cultural resource management across the state. Next slide, please. So the central research question is how and whether California's cannabis permitting process is consistent with tribal sovereignty. And the way that question broke down for us was first of all looking at what the concerns are for tribes around cannabis, why cannabis in particular might be concerning. Also, what mechanisms exist to protect tribal cultural resources. So what affordances in the law and what other kind of relational capacity exists to protect cultural resources from cannabis projects. And then finally, always asking a practical question of what can state and local governments do to strengthen and improve those processes. Next slide.
Oh, yeah, let me take over here. Hi, everyone. Thank you, Ted, for the introduction. Hi, everybody. Nice to see you all here. Thank you, Jeremy, for getting us started. So yeah, methodologically, this was a mixed methods project, but we relied a lot on qualitative data in the form of interviews and a couple of surveys that we made on Qualtrics and sent out across the state. We started with trying to basically reach out to every tribe in the state. That's federally recognized tribes and non-recognized tribes across California. We use lists from the Bureau of Indian Affairs and also the California Native American Heritage Commission, basically to compile tribal lists of federally recognized tribes and non-recognized or California state recognized tribes. We conducted about 85, or we talked to 85 people over about 65 interviews, spanning about a year and a half. And one of our key questions was really the impacts that tribes were seeing from cannabis permitting, but that question often quickly went into other realms, which we'll get into. Quantitatively, the data that we used was really just the California spatial data, where tribal ancestral territories lie, and county data. So, the quantitative spatial extent of California. Let me advance here. And that kind of brings us to a central point in how we think about all of this throughout this conversation, is just how we conceptualize the state of California and how we think about ancestral territory or indigenous land, native land. This panel to the left shows a federal map from the EPA, which shows the actual reservation land and trust land that is held by the federal government, which is seen as tribal land in the state of California. And perhaps you can see it, probably a small window on your computer screen, but they're very small polygons throughout the state, which make up less than 1% of the state's total land area. That's one way of thinking about ancestral land. But for this research, really what we're looking at is ancestral territory, which encompasses the entire state. We're not thinking about just current land holdings, but the entire mosaic of California being indigenous land and therefore relevant to the conversation that we're having around protecting tribal cultural resources. And we'll come back to this in a little bit, but the center panel shows a pretty standard map that is a product of research that was done in the 20th century looking at linguistic stock around California. And this has become kind of a standard representation. The one that's shown here is from the California Indian Library collection in the 1990s that's been digitized and used across the state. And then to the right, we have Native Land Digital, which is a nonprofit that asks tribal entities to send in their own shape files, which are displayed here. And you can see that there's a much different sort of representation and overlapping as opposed to these static cartographic boundaries that you're sort of used to in Western mapping. So some of our key takeaway findings that we'll get into in the next few minutes here were that cannabis sites frequently coincide with areas that are rich in tribal cultural resources. Tribal cultural resources are more than strictly archaeological sites, requires sort of a deeper understanding of what a tribal cultural resource is. It's not just areas where there's human remains or archaeological artifacts that could be found in a discrete area. There's kind of more to that story that we'll get into. And also probably the most pressing takeaway from this study was that consultation is vastly important, and there are many inherent challenges with achieving meaningful consultation. And those come in the form of AB 52 and the laws meant to protect tribal cultural resources, and also the attitudes and processes of county agencies and state agencies and how they go about consulting with tribes. And then there's some technological or technocratic elements as well that kind of create hurdles or challenges that have to be thought about in this protection of tribal cultural resources. Jeremy, let's go back to you for these.
Yeah. Great. So in one sense, looking at cannabis permitting opens onto other kinds of land use types, including agriculture, but also housing. Any kind of development, there's implications for any kind of development here. But in another sense, cannabis is actually a good way of looking at the kinds of impacts to tribal cultural resources. And that's because right off the bat, we heard from several different people that there's a coincidence of cannabis sites, ideal sites for cannabis. That is, they have southern exposure, low slope land, near a source of water, and land that would be used historically or currently for cultural resources. And so what that means is that cannabis operators, both historically and currently, are actively selecting for tribal cultural resources. That also points to significant impacts. Next slide, please. So in case you're not familiar with Native American studies, what is a tribal cultural resource? So in the Public Resource Code, it's defined as sites, features, places, cultural landscapes, sacred places, and objects with cultural value to a tribe. That's a recent definition. This is within AB 52, which I'll talk about in a moment, but came into effect in 2015. And it's a fairly capacious definition. However, I think you could also say that it's not complete. When we actually asked this question to at a Cal TIPO convention with tribal historic preservation officers from across the state, people pointed out things like stories and other kinds of phenomena that you could say are both intangible and have a more relational quality. And so basically, we're not just when we're talking about tribal cultural resources, we're not just talking about archaeological sites, and village sites, grave sites. We're also talking about places of active use, gathering sites, hunting grounds, landscapes, cultural landscapes across the map are laden semiotically, and so this is really I think what's important to point out here is that if you don't have cultural knowledge, you wouldn't necessarily know to recognize one. So there's anthropogenic signatures that an archaeologist or someone who is not a cultural insider wouldn't necessarily recognize. And yeah, and so what we found is that there's high variability in how this definition is being applied and operationalized by county planners. And so even though this is a capacious definition, it's not always, there's not always, if there's not tribal involvement, then it's insufficient, is one way to put it. Next slide, please. So these are, cultural resource laws are the mechanism through which cultural resources are protected in land use planning and development. Historically, tribes have had to make use of cultural resource laws like NHPA and NEPA, which were not necessarily designed to protect tribal cultural resources. And so it was a strategic use of these statutes, and they worked for better or worse, and often for worse. What makes California a really distinct environment to look at this is that you have some of the most progressive legislation across the nation. And so in 2004, SB 18 went into effect, and that brought consultation to the local level. One major disadvantage of SB 18 is that it only takes effect when there's a general or specific plan update, like zoning law change. And so this kind of consultation can be intermittent. What AB 52 did in 2014 is it actually brought consultation into the CEQA process, which in principle at least happens with every single project that comes across a planner's desk. And so, the frequency of consultation is greatly increased with AB 52 as part of CEQA. Next slide. Next slide, please. So this allowed us to, so basically what happened with AB 52, which if you notice the date 2014, it comes into effect just before legalization in California, 2016. And so legalization, because of the coincidence of tribal cultural resources and cannabis, and because AB 52 and cannabis legalization are so close in time, legalization acted as sort of a stress test for how AB 52 is working on the ground. And so you had an inundation of permit applications that went to county planning offices that may have had a track record of interacting with tribes. Many of them didn't. And so what we saw through this experience is a lot of the gaps and challenges within the consultation process. Also, I think important to note are some innovations that came out of this. And so we'll get to that too. In one of our articles that's come out of this project, we talked about barriers to consultation. And so this list of barriers rhymes with a lot of the barriers that you've seen historically under different statutes. But there are also some important differences. I think at bottom of this is agency discretion. And what that means is that agencies have the final say in terms of how to apply the law, what counts as a substantial effect, and what a proper mitigation measure is. And so with agencies have that kind of decision-making power, it sort of undermines the way that it undermines tribal standing from the get-go. And so we saw this firsthand in the case of cannabis. A lot of counties rolled out cannabis using interim and provisional permits. One county called it early activation. And these were mechanisms to transition legacy growers to the legal market. But in effect, it allowed people to operate without completing their CEQA review. And so from the standpoint of protecting tribal cultural resources, you can immediately see how this becomes an issue. We also, found that weak enforcement really undermines the efficacy of the law. So, for example, a lot of agencies in the realm of cannabis operate on a complaint-based system. So they really only enforce if there's a complaint that that severely weakens the way that the law is implemented. And then, of course, there's differences that we'll hear more about in a little bit between tribal and archaeological perspectives. Knowledge gaps. Seth, in a moment, will talk about some of the problems with mapping and our information systems. And a perennial challenge is port capacity. There's a lot of turnover in not only tribal offices, but also agency planning offices. And there's, in general, kind of a lack of funding to really build up and do all the scaffolding that would make consultation go well and also make development projects go well from a tribal cultural resource perspective. Next slide. Back to you, Seth.
For the unmute. Thank you, Peach. Okay, so this brings us to kind of what I was alluding to before, the technological challenges, or the technological side of things, mapping. As mentioned earlier, there's these different kind of ways to understand the land use in California regarding Native Americans or tribal groups. This image kind of emphasizes that. We're looking at the Bear River Band territory in Northern California. The inset map shows it's up in Humboldt County, and I think it reaches actually down into Mendocino County. Anyway, you can see that the red polygons are actually federal holdings of tribal entities, the Wiyot tribe, Blue Lake Rancheria. But the cultural area in green, the larger polygon, that's the ancestral territory of all four of these different federally recognized tribal groups. And so this is sort of hopefully kind of enable you to visualize the scale of the problem when you have the actual physical land holdings be these fairly small, just a few acres actually of land over a vast land area, thousands of acres of land. And this legal requirement from the part of tribes to sort of consult if there's a tribal cultural resource that is threatened from a development project. So just to kind of reinforce what Jeremy was talking about earlier, when we have the passage of Prop 64 and this increase in volume of requests for tribes to sort of consult on projects that are happening across their ancestral territory, it's just kind of a vast challenge where you have these fairly small tribal offices trying to deal with this really large land area that is obviously not owned by the tribe and is oftentimes most times owned by private developers or the state. And then that creates a whole conversation that has to occur in order for consultation to happen. So in short, maybe too late, I went and tried to ask tribal representatives and agency folks as part of our interview process how maps played into their process and how mapping technology sort of influenced consultation outcomes. What we heard back was not overwhelmingly negative, but tilted towards the negative side. We heard that from agency officials saying things like, we don't actually have a lot of maps for the tribes that are around us. We heard from tribal representatives saying that the Native American Heritage Commission isn't doing such a great job of giving correct information out. Some of our neutral responses were more sort of like, tribal territories can change, or an agency representative might say something like, we have a database and we're working on it. So we went through and kind of qualitatively coded these responses to get a sense of what people's sort of leaning was towards the mapping protocols in California. And it came back, around 60% dissatisfied. That number was more so with tribal representatives and agency reps, but an overall sort of dissatisfaction with the way that the state is managing its maps of ancestral territories. So we did a bit of a comparison here where we looked at those mapping layers that we talked about earlier, that we looked at the panels. We looked at the differences between the handbook layer, which was that central panel digitized by the California Indian Library Collection, and the native land digital layer, which is an open source layer, and kind of did a spatial analysis laying those two layers on top of each other, and did something called an intersection over union analysis, which we use in machine learning a lot to see how accurate a model prediction is. And you can see on the images here, for instance, Chumash territory in what county is that? That's Santa Barbara County, thanks. Yeah. So down here in Santa Barbara area and the Chumash territory, you see these different size polygons can create quite a difference in consultation outcomes. If you have a handful of projects that are taking place somewhere in this region, what side of this polygon line they fall on can have pretty dramatic implications for tribal cultural resource protection. If tribes are not notified, or if the wrong tribe is notified, or the wrong entity is notified, that can circumvent the consultation process before it even gets off the ground. And basically what I found by doing this, what we found was that some areas like Sinkyone Wilderness, also up in Humboldt County, which isn't a tribe per se, but kind of like a wilderness area protected by a consortium of tribes. The two mapping products align very closely. Their intersection over union is close to 90%. So we wouldn't see a lot of discrepancy there. But you have other tribes where there's a huge discrepancy in how the state designates their ancestral territory and how they themselves portray that territory. So this is a major challenge that I think came up again and again. The consequences, as it says here on the bottom of the slide, is non-compliance for AB 52, and also just sort of a lack of trust from the part of tribes towards agencies if their land area is continually misrepresented from the part of the state, which can lead to just poor relationships and less consultation outcomes. The recommendations that we have, well, we have many, but the ones that we have here today are sort of a collection of some of the most pressing takeaways that we found and stuff that we want to share. But they all kind of fall broadly in these three bins of protecting tribal cultural resources and how to continue to make that a priority, strengthening enforcement and monitoring, because without proper tribal monitors, again, these cultural resources can kind of slip through the cracks without anyone even being aware that they're in jeopardy. And also, most importantly, perhaps, like Jeremy alluded to earlier, a lesson that's learned again and again with operating from the state and trying to negotiate with tribes, consultation, government to government consultation is the most important factor. And making sure that is meaningful and robust is even more important than the consultation itself, making sure that it's in fact meaningful consultation. I'm going to talk about the first one or two of these, and then I'll hand it back over to Jeremy. So as far as protecting tribal cultural resources, there's a number of pathways here. We've listed a few, but yeah, in terms of AB 52, which again is it's part of CEQA. It was added onto CEQA in 2015. And so thinking about ways that CEQA exemptions can threaten TCRs. If a project goes through CEQA and is determined by the lead agency to be ministerial or to have low impacts, then there's a chance that the tribe itself wouldn't even be notified. There would never even be a consultation letter. As far as some of the technological stuff I was talking about, modernizing the state system of cataloging ancestral territory. This goes really long and we really don't have time for it here, but between the Native American Heritage Commission and the CRIS system, which is the California Historic Resource Information System, there's sort of just this Byzantine network of information that's really kind of hard to access, perhaps can be accessed by some of the wrong actors. Landscape architects, for instance, can access the CRIS system that have no understanding of cultural ancestral territory, tribal cultural resources, And so there's issues there. Modernizing the state's GIS capacity, both for the state itself and also creating programs that tribes have access to GIS resources. Federally recognized tribes have access to ArcGIS through the federal government and through the BIA, but there's no system in place that allows tribes in California to get free access to geospatial tools from the state. I think that could be a major improvement. And then those databases need to be regularly updated and done so in accordance with tribal data sovereignty principles and making sure that tribes are the final arbiter of what information is shared on any map, on any state map. And as I mentioned earlier, there's really all of these solutions kind of fall under the umbrella of consultation, because without meaningful government-to-government consultation, these are all sort of interim fixes to a larger problem. The most successful approach that we keep hearing about and understand is a robust conversation that starts early and goes on often throughout a development project process. So nothing can sort of top government-to-government consultation. And I'll wrap it up here with enforcement and monitoring. This was also just a really large issue, hard to cover in just one slide, but there's issues, again, around the tapestry of policy across California. We have 58 counties implementing remediation or monitoring or doing enforcement, really vastly different ways across the state. You have counties that are permit counties where they have legal cannabis permits. There's other counties that are complete ban counties. So you have different enforcement approaches from law enforcement and code enforcement. And how that intersects with tribes and tribal sovereignty is that there's just a myriad of ways that things get done, and some standardization around outreach and communicating with tribes, understanding what tribal values are in a given area are really important, with making sure that mitigation strategies are actually effective for the people that are on the ground and whose land we're ultimately trying to steward and take care of. There's a picture here, just a small case study in Siskiyou County, where the basically subdivision land line moved. And you can see on the right, again, it's probably a pretty grainy picture, but a lot of old cannabis parcels that were sort of abandoned. And now you have plastic and environmental kind of degradation happening left on the landscape, plastic resources, PVC left on the landscape, degrading with no clear path forward as to how to mitigate that. So this came up again and again with tribes, concern over who was enforcing laws to make sure that cannabis cultivators were operating under the rules already there, and then who was responsible for the land once an operation ended and there was environmental degradation. Oh, and importantly, I think something I missed was cultural surveys. In the process of a development project of any kind, making sure that cultural monitors are on site to understand, what's happening on the ground, not just showing up after the fact when degradation's already occurred, but being part of that process to ideally, ensure that degradation doesn't happen. Yeah, and I think that basically, and again, making sure that experts are seen as not just archaeologists or someone that maybe fits the expert role by the letter of the law, but that true tribal experts, cultural resource specialists are brought in on the ground to understand what's happening in that particular area. And then here, let's go back over to Jeremy to do the last couple.
Yeah, so I think if there's one takeaway from this presentation is that there really is no adequate replacement for government to government consultation, and that's for a myriad of reasons. Seth talked about problems with information systems and mapping. The state and the counties simply don't have that information. Archaeologists can't always identify a tribal cultural resource. So for all those reasons and more, tribal cultural resource protection really does come down to this. And so not just consultation, but meaningful consultation. And what that looks like is, that depends on the integrity of relationships, having strong government to government relationships. But I think it's important to highlight that there's a lot of infrastructure that goes into building those relationships. And so this slide offers some ideas about how to strengthen those relationships. One thing that we would like to say is that the way that it works right now, in principle, is very good. That the local planning, the local governments are the lead agency for CEQA when it comes to cannabis, and we think that having CEQA happen at the local level, having consultation happen at the local level, um, is ultimately a good thing because you can really build those relationships. Those relationships are face-to-face relationships. They are at the local level. And the knowledge about the land and the impacts and environmental conditions, a lot of that transpires at the local level as well. Now, earlier I talked about variability across counties. And so we also think there's an important role here for the DCC and other state agencies to really backstop those relationships and ensure compliance. Currently, the way it works is that the local government is the lead agency for CEQA, but that you still have, if you're a cannabis operator, you're still getting your license at the state level. And we actually think that's a really good setup that holds the most promise for really cultivating these relationships over time. The other part of this is capacity. So, there's money coming from cannabis tax that can really help if there's funding for tribal historic preservation officers to staff up, to develop their GIS systems, to put cultural monitors on site. And also, we think the state could play a really helpful role here facilitating co-learning. And one of the things I want to talk about, next slide. One of the things I want to talk about is innovations that are happening at the local level. So one innovation, for example, is assessing applicants for cannabis it's what they call it in San Diego County is a cultural assessment fee. And that goes directly to the tribes to not cover, but supplement some of the costs that they incur to do the review work and the cultural monitoring work. That's so important when looking at these projects. But one of the innovations that I really want to highlight is from Humboldt County. And so Humboldt County actually, in consultation with tribes, amended their cannabis land use ordinance, and they call it CLUO 2.0. And so this was in 2018. And so the tribes were working together with the county, and they pushed to add language into the land use ordinance, which basically said that tribes are uniquely positioned to designate tribal cultural resources. It doesn't have to get an archaeological review. It's tribes that really should decide if there is a cultural resource or not. And if there's a cultural resource, then tribes have authority to say whether the project can move forward, which usually meets out in terms of what are the mitigation measures that would be important to protect those cultural resources. And so the planner that I spoke with was saying was calling this a two-key ignition system. You need approval from the planning office. You also need approval from the tribe if it's within the ancestral territory of that tribe, and there's a tribal cultural resource in that area. And what this is, basically this is a concrete expression of giving tribes real decision-making authority. So not just saying, okay, under AB 52, we get to, we consult, which can look like box checking, inviting tribes late to the party to fulfill a bureaucratic requirement. This is saying, no, tribes are there from the beginning, and we need their approval for this project to move forward. Now, the planner I was speaking with was really frank and said this was scary for a lot of people at the time, because we're not just talking about trust land. We're talking about public land. We're talking about private land. What people can do, where they hold their title to their land, and so there's this pressure on property rights, through this. And what the planners said is that the tribes have been really judicious in their use of their authority in land use decision making, and he thought it was going really well. So, I like to highlight this case as a moment where a county actually went above and beyond CEQA in some respects with really good results. Yeah, I think that's yeah. So the main point there is that, if you have agency discretion in place, or the county planners are not fully sharing authority, land use decision making authority with the tribes, you're not getting the results. And so there are ways to actually share that power more equitably. This last slide is really just a summary of some of the things that we did with the project. If you're interested in learning more about some of the topics that we've covered, we've published several articles. We have several more in the pipeline. And we also did a webinar that I think you can find on our website, along with our final report and the consultation policy template that I mentioned earlier. This is all, if you go to the CRC website and look for the tribal resources page, you can find there's downloads. There's also a ton of other, cannabis permitting information and other links, relevant to this project that we've assembled for people really interested in this. So with that, I want to pass things off to, we're going to hear first from Anna Starkey, and then from Earl. And again, these are folks who've worked in tribal historic preservation offices and have been doing this work for years. And so so it's really great to hear their perspective as people who've actually worked in this space. Anna.
Oh, good morning, everybody. Thank you for coming to this webinar. I did wanted to talk about not specifically how cannabis impacts tribal landscapes, but to touch on how AB 52 and tribal values and how now the tribes get to consult under AB 52 for the identification of tribal cultural resources and kind of what that looks like from the tribal perspective. So earlier, there was a discussion on AB 52 and how tribes are able to consult for the identification of TCRs now. One of the things that tribes, and I can only speak on behalf of United Auburn Indian Community because all tribes are different and their preservation officers and how they go about their identification. Everybody's different. All tribes are different. So when I speak, just remember I'm only speaking on behalf of the tribe that I work for. So there's a big misconception on how tribal cultural resources are identified. One of the things that we often find is that some agencies, they think that tribes already know where all their resources are located. So a lot of these lands are private property. And so we don't know if there's a tribal cultural resource there or not. So we have to conduct a survey. Now, archaeologists go on surveys all the time and they get compensated for that. So all of this identification work is all on the shoulders for tribes to have to pay for themselves. They have to have the staff availability and they have to have the time to get out there to these sites to be able to survey for the identification of TCRs. So that does present a large burden for tribes. Whereas, if you have a biological survey or any other type of survey for the environmental CEQA document, those surveys get compensated for. So that is one of the problems that we're facing, that it's just kind of like unbalanced, it's lopsided. So if a tribal cultural resource is identified, I'll give you an example. So bedrock mortars. Bedrock mortar sites, they're ubiquitous in UIC's territory. You find them everywhere. So an archaeologist would often say, oh, well, this is a ubiquitous resource, so therefore it's not unique. If it's not unique, it's not significant. So it can't rise to the level of being eligible for the California Register of Historic Resources. That means it has special protection. So, but from the tribal perspective, their ancestors used that. That was their kitchen. That is where they processed their food, their medicine. So of course it's significant. Of course it has meaning, and they don't want it to be destroyed. So when you get the tribal values in there compared to archaeological values, tribes now have the ability to protect and preserve that bedrock mortar where it could otherwise be destroyed if you only had the archaeological viewpoint and the archaeological values being applied to that resource. So AB 52 has completely opened the doors for tribes to be able to get in there and be able to explain and consult. And that's where meaningful consultation, I have starred in my notes, is so important to be able to get that across to agencies, how important tribal values are in the identification and preservation and protection of tribal cultural resources. And to expand on that, you have a bedrock mortar, and it's not just there on the landscape for no reason. So that's where the whole cultural landscape gets tied in, and how you have to look at it as a whole. You don't just draw a polygon around that little bedrock mortar site and that's the site. No, you look over there and there's an oak tree. You look over there, there's a creek. You look over there and there's a hill that they could have had a village site looking down on. So it's not a polygon here and a polygon there. It's an entire landscape that is all connected. And when you have these projects that are in one space, and then you have another project in another space, these cultural landscapes get disconnected, these cultural sites get disconnected, and they have little polygons separating everything. And so you don't see it as a whole anymore. And the landscape is a whole and it's all connected. And so we're really trying to get that across more when we're consulting, is more taking the landscape approach and how everything is connected. So anyway, that's my spiel. I just wanted to really put it in perspective of the tribal values and how something can be not unique from an archaeological perspective, but very significant and meaningful and worth protecting from the tribal perspective. So thank you.
Earl, did you want to take it away?
Yes. Good afternoon, everybody. Or actually, still good morning, but close enough to afternoon for me. Anyways, I'm Earl. I worked for the Canuck tribe for 20 years. No longer retired from working for the Department of Natural Resources of the Canuck tribe. So, as Anna said, I only speak for myself. I don't speak for the tribe. But I want to, touch on our experience. It's story time a little bit right now. Is working with Humboldt County. That was a very unique opportunity for, I would say, for a communal learning on both ends, on both sides of the plate, as you'd say. We were able to, get in early during that ordinances being put together and have that language put in to where the tribes would be consulted. But the Canuck tribe went a step farther and was able, to come up with our own agreement to engage directly with the cannabis permittee on a one-to-one basis and not have the county be that go-between. So that really helped to have that agreement in place with that permittee, so we would be able to, get reimbursed for our time and also be on the ground to see what impacts that cannabis operation has in the past and what that impact to cultural resources will be on the future if it is allowed to go forward. And, as Jeremy was saying earlier, we were very, we were good. If we could find a mitigation for that site, we would, I wouldn't say we approve it or disapprove it, but we would recommend that permit be approved through the county. On other ends, where folks were didn't want to engage the tribe, didn't recognize a tribal's authority, then we just had to assume that whatever that site that they were growing their cannabis on or were proposing to grow their cannabis on did have cultural resources, and those were not able to be mitigated, those impacts, since we weren't able to go actually take a look at it and have the discussion. So, make a long story short, that ability to actually engage with the permittee really help both the county and the permittee and the tribe to ensure that those cultural resources are being protected now and into the future. And once again, not once again, but I think the key takeaway from our relationship in this process with any agency, be the feds, be it the state, be it the county, um, would be relationships. We had built relationships over the years, and we maintain those relationships even though staff changes. We still have those frank, honest discussions with each other to be able to understand where folks are coming from. And that's all I had to say on that subject. Thank you very much.
Well, that brings us to the end of our presentation. Yeah, thanks so much for listening. And I think we have a few minutes. Looks like we have maybe 10 or 15 minutes for questions.
Yeah, thank you, Earl and Anna, so much for sharing your perspective. It's even though we've known each other for a few years now, it's always great to hear you guys talk from your perspective as tribal representatives and the work that you do. So thank you.
Thank you.
Thank you.
I'm happy to lead off with a question. This was great. I really appreciated all the insight. I guess one of the things that struck me in the initial presentation was that I think a lot of your recommendations seem to be really extend beyond cannabis, right? Really could be generalizable to thinking about best practices for tribal engagement and consultation um, that are not unique to cannabis. And so I guess I'd be curious to hear your thoughts in kind of thinking about that and you know, is that true? To what extent are these recommendations just sort of are they generalizable, or what is sort of unique about cannabis in this context that maybe requires I guess sort of particular consideration? I don't know if we want to start with Seth and Jeremy and then pass it on to our tribal partners, but
I think Jeremy should handle this because I think you have a good answer for this one, Jeremy, if you don't mind. But I will say that, as I alluded to in the method section, reaching out to 110 federally recognized tribes, 50 or 60 non-recognized tribes, and saying, "Hey, how is cannabis impacting your tribal cultural resources?" A lot of tribes were like, "I don't want to talk about cannabis," right off the bat. And it became apparent that the issues that tribes were facing around tribal cultural resource protection and AB 52 and development went far beyond just the lens of cannabis. But this is where I think Jeremy should take over. I think this lens that the passage of Prop 64 created, this ability to sort of look at AB 52 working in real time. But anyway, yeah, go ahead, Jeremy, if you don't mind. You say it better than me.
Yeah, I'm curious to know what you what you're alluding to, Seth. I mean, I think as one thing, as I mentioned earlier, is that there is this coincidence between sites selected for cannabis and tribal cultural resources. So, in other words, there's a high probability that if it's going to be a good place to grow cannabis, it's also, a good place to camp or gathering ground or ceremony site. There's a good chance you're going to have tribal cultural resources there. So that's one way in which cannabis is unique. But Ted, I think you're absolutely right that, a lot of our findings, I think, can be generalized far beyond cannabis. And, I think one thing that I'm still thinking through is some of the jurisdictional complexity. I mean, it really depends which agencies we're talking about and under which cultural resource laws we're working. And I think one of the interesting and unique things about cannabis as a test, and as I put it, of AB 52 is that you're now having all this consultation at the local level. When we interviewed people in 2022, I think only 1/3 of the county respondents to our survey were actually said, yes, we're working with tribes. Hopefully that number has increased since 2022, but I think it points to some of the growing pains. I mean, you get AB 52 in 2014, and then, almost a decade later, people are still trying to figure it out. And, it's, I think, typical California say, hey, everyone do this. And then, but figure out how to do it and fund it. And so, yeah, maybe another headline for us is, don't make these kinds of mandates unfunded. Like the funding is incredibly important. Having guidelines in place, really building capacity for this very complex work. But to go back to the cannabis question, I think that having all of this consultation at the local level is what made this a really interesting natural experiment for us. I think the state agencies in general tend to have more experience doing this kind of consultation, and so yeah, there was a lot of, I think it unearthed a lot of the fissures and fractures in the consultation space, to talk to people on both sides who are interacting potentially for the first time. But yeah, which is not to say that like cannabis is the only way that this matters. What's really cool about AB 52 is that any kind of development project that passes through CEQA is now subject to this process that can lead to tribal consultation. So, yeah, I guess that's what I would say. Anna and Earl, not sure if you want to add to that.
I mean, I can add to it, I mean, just real quickly. Yeah, it does go beyond the cannabis realm. The responsibility and just a good neighborly and be a good human to each other transcends just the cannabis permitting. The counties and the tribes should be having these discussions to ensure that those tribal cultural resources are not being impacted. And if they are being impacted, how to mitigate. And if there is no mitigation, then where do they go from there? Is it a non-project? How does that work out? That's where the discussions and those consultations with staff and then ultimately with tribal council come in to be able to make those decisions.
This is Anna. Jeremy touched on previously in his presentation about the landscape and how a lot of times the preferred locations of these cannabis grows are in locations where a TCR could likely be based on landscape, based on proximity to water. And when this got passed, there was a green rush, so to speak, and there was a lot of applications. And so that just means there, some tribes I've heard were completely overwhelmed. You can't get out there and survey for all these locations. And so there absolutely probably was impacts to TCRs that no one even knew about and still don't know about. And that's mainly because, again, the locations of the grows are often associated with where TCRs are likely located. I don't know. Did that answer it?
And then maybe one more thing I was thinking while everyone else was answering was, of course, outdoor cultivation, especially, you're digging into the ground, and that's a big feature or, factor of just being a cannabis cultivator is that you are going to be interrupting the ground. And that's something that had a lot of sensitivity with everyone that we talked to. So, yeah.
Well, even putting up indoor grows is going to dig the ground up.
Sure.
So.
I think one other point I'd like to quickly make is that I guess what's exciting to me about seeing AB 52, hit where the rubber hits the ground with AB 52. I think of AB 52 as in a way still aspirational, and I like to bring up the Humboldt case because I think there's going to be future legislation that goes even further, right, and gives tribes more authority and more agency. And I think what we can actually think of this as working toward a place where tribes and agencies can come together as equal partners to steward the land and really making better and more use of tribal visions and historical relationships with that land. One thing I've talked about, not necessarily with Earl, but I think it was with the current TIPO or TIPO's office for Karuk is how working with tribes can be this broker when you have cross-jurisdictional issues. And we all know that environmental issues are often cross-jurisdictional. But whereas you have kind of a logjam of different agencies that butt up against each other in terms of jurisdictions, tribes might be able to kind of broker good solutions if they were given the authority to really have a say in how these cross-jurisdictional projects go. So just a quick point I wanted to make. I see that there's some questions in the chat. We could go there as well.
Yeah, I think there's one that kind of builds off what you were just discussing, and this was could Earl talk a little bit more about how the good relationships between the tribes and Humboldt County began, and how they could be sustained or how to sustain them?
Yeah, that one's relatively easy. It all began, which is having those personal relationships. And as far as back as I can remember, it began with, the Klamath Dam removal, where you had, the counties, the tribes, and the feds and the state all in the same room discussing the dam removal issue. And, our representatives making those inroads to those county folks, the board of supervisors, and also some of the planning staff, and impressing upon them that the tribe, the Kuduk tribe, and to an extent, I can't speak for Yurok or Kuduk, or Yurok or Hoopa, but reasonable people. And when you're the reasonable person in the room, then people will gravitate toward that and actually listen to what you have to say to them, and actually will act upon it. So and then also that relationship was further cemented by the North Coast Reshore Partnership, where we have tribal representatives on the board, and doing the same thing, interacting with other board of supervisors in the other 3 counties or 4 counties, and also interacting with those planning staffs to be able to build those interpersonal relationships. I'm not saying it's all roses and everything's great, but we work through those issues that we came across them.
The importance of building good relationships with agencies cannot be understated. I'll give a really quick example, if that's okay. There's a housing development project going on in West Placer County where we consulted. The tribe consulted many, many, many years ago. And for some reason, we weren't allowed to have paid tribal monitors beyond a certain area, even though there was resources and fines, cultural fines beyond in that area. For whatever reason, during consultation, this was before my time, they didn't allow it. I think it was a budget thing or something. I don't know. So anyway, we consulted on this project again. Remember, this EIR is done. It's been done for a long time. And because the county knows that there were cultural fines in that area, the county has agreed to, so even though the secret process is done, we're going to have a conditions of approval, and the county is ponying up $25,000 to pay for tribal monitoring in that area. And they're doing it, even though the CEQA document and EIR has been completed, we're doing it as a conditions of approval. So things like that can happen. Anyway.
Just being good humans.
Yeah. Having good relationships.
Yeah, and not to pivot back to the negative side of this, but we did, through all these interviews, talk to so many counties that just said, "Oh, we don't have tribes in our area," or "I don't have relationships with anybody from the tribe." And it was like
there is that too. Very
matter of fact, sort of ignorance around the importance of this. So I think saying it again and again is important, and to as many audiences as we can, because
Oh, that was only one positive highlight. I have more than a dozen negative things that have happened, believe me.
Sure.
It can be very, very, very challenging.
It is. Well, different counties have different perspectives on tribal presence on the landscape and what that jurisdiction is.
Mm-hmm.
Some are
started with Army Corps.
Yeah. I'm not sure they're stuck in the 1850s or the 1950s sometimes.
Mm-hmm. And honestly, AB 52 is so much better to consult on than the Section 106 on the federal side, because it's either a historic property is present or not. Historic property means it has to be eligible or potentially eligible for the National Register of Historic Place. So that makes having something like a bedrock mortar site very, very challenging to say that it needs to be avoided and protected under federal law.
Yeah.
And then maybe lastly, interestingly, when we started doing this research back in 2021, AB 52 had been up to that point unchallenged legally. And now there has been a pretty big lawsuit in Lake County on the part of I think it was Koi Nation, is that right? That actually on AB 52 grounds that the county wasn't doing its part in following the letter of the law to protect cultural resources, in which the tribe won. And so now I think we are, to Jeremy's point earlier, kind of going into like a new era of AB 52, and I think it's going to hopefully become stronger and more robust and more understood by agencies as time goes forward. So yeah.
Mary Claiborne, Claiborne, did you have a question? I saw you raise your hand.
Mary has a question in the Q&A, Ted, if you want to look at
Oh
that.
yeah, okay. It was the question in the Q&A asks if in her jurisdiction they've seen cultivators propose above ground cultivation in beds or pots. Is this preferred? I think this is in relation to kind of an earlier comment about the ground disturbance associated with a lot of cultivation methods, and if there's any thoughts on that.
I have a thought on that because that was one of our mitigations. This is Earl. Yeah, but it's up to the tribe. I mean, if the tribe deems that to be a acceptable mitigation, then yeah, I don't see a problem with it. It's better than people digging and uncovering artifacts.
Yeah. Great. Yeah, there was another question about other examples, beyond the Karuk tribe in Humboldt County of good relationships, and I think Anna provided a really excellent example there. I had a question circling back to the kind of topic of mapping, and yeah, Seth, I thought it was really interesting the sort of how obviously mapping ancestral territory has implications for resources. I also this didn't really come up explicitly, but the issues around mapping tribal cultural resources. And I'm curious if Earl and Anna would like to share their thoughts on this, because I think on the one hand, if some of these tribal cultural resources are mapped, you could help, build awareness and perhaps influence, how people think about potentially avoiding impacts. But then I know there's also a lot of sensitivities around sharing, obviously a lot of sites that you don't want to be in the public, domain, or maybe resources where you don't want that to be shared, or that the tribes really want to retain control over this information. And so I guess I'm just curious how you think about maybe the opportunities or advantages of mapping tribal cultural resources versus some of the risks or concerns around tribal cultural resource mapping.
I can jump in real quick because we deal with this a lot. There are methods to map tribal cultural resources that don't give away exact locations. You can do heat maps. You can do general sensitivity maps, which are pretty good for general plans. And you don't have to give away exact locations. However, depending on the project and the agency, sometimes it's more beneficial for the agency to know where a resource is. That way it can be avoided and protected. And sometimes the landowner should know. It's his property, and say, hey, you have this cultural resource here. You need to have setbacks. You cannot build within 100 feet of it, for example. So there's ways to be able to still provide maps, but not give exact locations. And usually we like to have big buffers around sites anyway, just in general. But Seth, you probably have something to add to this too.
Yeah, I could go long on this.
I bet.
This is what I was alluding to about Chris earlier. I have a few things I want to say, but I guess I think the most important one, Anna, you alluded to this, the idea that like for once you've designated something, it goes to the National Historic Register of Important Places, whatever. The same thing happens with the CRIS system. Is when the tribe designates a cultural resources through the CRIS system, the state of California takes that item or object on in trust for the future of California. That's the language in the law. It's for the future citizens of California. A lot of tribal representatives talked to me about this and said, well, we don't want to preserve our cultural site for the future of all California citizens. We want to preserve our cultural site for the future of our tribe. This is our culture. We don't really care if the state of California wants to preserve it. we want to preserve it, and so there was tension there that a few different representatives talked about not giving data over to the CRIS system because they didn't want that to become trusted by the state of California. They wanted to retain the ownership of that. And another interesting one was that we didn't get into here today, but again, so many different tribes, so many different objectives and values across the state. There's not always good relationships. And there were instances where tribes were like, we don't want to put our boundaries or sensitive site information into the public domain because some of it might be in dispute with neighboring tribes. And so there's just a lot of sensitivity around relationships there again. And lastly, I'd say that one that came up a few times that always kind of made me chuckle was like the idea of not a super formal process. I think it was like Yoche Dihe was saying, we sit down with the planners in YOLO and we say, this site's off limits. We don't really want to talk about why. And that's okay. And then in other sites, they say this site's off limits, but yeah, sure, if you want to put an access road around the edge, we're okay with that. And so then planners sort of know informally the values again of the tribe, and they could say, oh yeah, this is an area that we're not even going to ask because we know this is a really sensitive area and we're not even going to question anything. Whereas other areas with good relationships, there could be an understanding of like, okay, maybe we can ask the tribe, is it okay if we put a road or a culvert in here? And have sort of that understanding at the outset of the conversation. So, yeah,
that's really helpful.
Right.
And I think we actually at time. So let's everybody give a virtual round of applause to our presenters and our speakers, especially Earl and Anna. Thank you much for joining us for this conversation. Really appreciate you taking the time to share your reflections and perspectives on this issue. I mentioned this earlier, but we are going to have a couple more events later this spring, and we hope you can all tune in. Particularly next month on March 5th, we have a conversation with you'll see more of Jeremy and Seth, but a few other folks from the Cannabis Research Center to talk about the unlicensed cannabis market and what's happened since legalization. And then there's this event at Humboldt State coming up soon in April. So keep in touch, follow our work, visit our website, sign up for our newsletter. Always look forward to hearing from folks outside of our research center who are interested in the nature of the work we're doing or interested in having a conversation. So thank you all for joining today. Thank you again to our presenters and speakers. And I hope you all have a great day.
Thanks, everyone. Bye.
Bye-bye, guys.